The Injury and Disability Law Center is a premier California law firm dedicated to serving the needs of people who are injured or who have become disabled. The lead attorney of the firm is a former insurance claims adjuster and has handled cases resulting in over $100 million in benefits to injured workers. The Law Center offers free consultations to determine if you have a case. One potential benefit for people who have been injured or disabled is the California Workers' Compensation System. This seminar outlines the basics of that system. However, this is only a general overview, and each case is different, and your specific experience and the law regarding your potential case may vary depending on any number of issues. The California Labor Code dictates the laws regarding what benefits can be obtained under the California work comp system. There are two sides in a work comp system. The applicant, which is the injured worker, and the applicant's attorney protects the interests of that applicant. The other side is the defendant, which is either the insurance company or the employer who might be self-insured. The adjuster and their defense attorney are there to protect the interests of the insurance company or that self-insured employer. The adjuster's job is not to protect you. The Injury and Disability Law Center exclusively works to protect you, the injured worker. The Law Center receives no legal fee unless you recover benefits. In California, workers' compensation is the exclusive remedy if you are injured on the job, with very few exceptions. Work comp in California is a no-fault system, so if the injured worker is at fault, or a co-worker, or even if the employer is simply negligent, work comp is generally the only remedy for the injured worker. There are some exceptions, though. In exchange for the no-fault system, California has limited benefits. Those limited benefits will be outlined later. California allows two types of injuries. One is a specific injury. You hurt your back lifting a box or being cut by a skill saw. Injuries like that. The second type of injury allowed in California is a cumulative or repetitive trauma case. So if you have problems with your feet due to prolonged standing and walking, or problems with your back because over time you've done a lot of hard work, or problems with your wrists due to typing or assembling, you can have a successful case. Cumulative injuries can also include internal issues, such as prolonged sitting, which has been associated with diabetes and heart problems. Prolonged stress has been associated with increased diabetes and cardiac symptoms. Also, any number of cancers are associated with exposures at work: diesel fumes, solvents, asbestos, prolonged sun exposure. And those types of cases also can be covered under the California work comp system. Assuming you have an accepted case, there are 5 major work comp benefits. The first is temporary disability. Temporary disability is a non-taxable weekly benefit with a maximum rate in 2016 of $1,128.43. It is generally 2/3 of your average weekly wage. That may seem very straightforward, but it's not. If you've had a recent raise, if you have a second job, if your hours were recently increased, all those issues can impact what your average weekly wage is, and the adjuster's job is not to ask those questions to help increase your benefit. That is how an attorney can help maximize that benefit. Temporary disability is generally limited to 104 weeks, with some exceptions. Knowing this limitation can help you be resilient and plan if you have had a serious injury. If you've exhausted the 104 weeks, it may also be possible to get state disability. A second benefit is called permanent disability, but a better description of that would be partial disability, where you have some limitations in your ability to compete in the open labor market or have some impairment in your activities. Permanent disability is determined and payable for the most part after a doctor has found that you have reached maximum medical improvement. This doesn't mean you won't get better or your condition won't worsen, but at some point your condition will become stabilized and you will get a permanent disability rating. That permanent disability will generally be paid at a lower rate than temporary disability. It is not taxable, and there is a limit to it. There are provisions for 100% awards, but those are very rare. If the adjuster gives you advances off your permanent disability rating, those advances will come out of any final award. It's important that you have a consultation with an attorney who knows work comp prior to getting a final MMI or maximum medical improvement report from a doctor, because how you present your final complaints to the doctor is very important in determining how that doctor rates your disability. The third benefit is medical treatment. You can receive up to $10,000 in treatment, even if your claim is ultimately denied. For accepted cases, there is an unlimited amount of treatment you can receive. However, there are lots of restrictions on how you get that treatment. You're also entitled to medical mileage when you go to the doctor. There is a limit to chiropractic and physical therapy visits. You generally have to choose a physician from within the insurance company's medical provider network to get treatment. When the medical provider network doctor requests treatment, the doctor must submit a special form called a Request for Authorization, or RFA. The adjuster does not have to take any action on your case until they get this form, even though they may have received a 10-page typewritten report about your need for treatment. The adjuster still does not have to do anything on that request for treatment until they have received the RFA form. So it's important that you make sure your doctor gets that form to the adjuster as soon as possible. This also includes requests for prescription medication. The adjuster then has 14 days from receipt of that RFA to do something, either approve, delay, deny, or modify the request for treatment. The adjuster generally will refer a request for treatment to a reviewing doctor called utilization review, and that reviewing doctor submits a report outlining whether the treatment will be approved or not. If the request for treatment is modified or denied, instead of going to a judge, the new procedure called Independent Medical Review, or IMR, is now used, and a second reviewing doctor will then make a determination on whether they agree with the treating doctor or the utilization review doctor. This procedure is currently being challenged as not constitutional under our California Constitution because this anonymous independent doctor is essentially the judge regarding your request for medical treatment, and there are only very few circumstances wherein a work comp judge can make a determination as to whether the treatment should be ordered or not. An attorney that practices a great deal of work comp will know how to maximize your treatment. Throughout your case, you may also see consulting doctors, and they could include either a panel qualified medical examiner, PQME, or an agreed medical examiner, AME. The panel QME, qualified medical examiner, is selected from a panel of 3 physicians provided by the state of California, and an AME, agreed medical examiner, is a physician agreed on by both parties. Both PQMEs and AMEs are used for the same purpose, which is to determine disputed issues, including whether a claim should be accepted through work comp, what percentage of disability should be, and what future medical care should be. Having an attorney at this point is critical because some doctors have a reputation of being sympathetic to injured workers, while some are more sympathetic to the insurance company. Those doctors will be using the American Medical Association guides to the evaluation of permanent impairment. Those guides are 613 pages. Most people think a disability should be cut and dry, and every doctor will rate a disability the same. However, the level of impairment is subject to a great deal of interpretation. As a matter of fact, 613 pages of interpretation. Having an attorney help you prepare for that exam and having a knowledgeable work comp attorney who knows which doctors may be best for your case is imperative at this point in your case. The fourth type of benefit is vocational retraining or rehabilitation. This benefit is available if you have sustained some level of disability and you are unable to return to work or your employer cannot accommodate you. For injuries before January 1st, 2013, the benefit could be up to $10,000. For injuries on or after January 1st, 2013, the benefit is a retraining benefit of up to $6,000, plus a potential right to an additional $5,000 one-time tax-free payment from the state of California. Sometimes, however, our goal is to help you keep your job rather than help you receive a retraining benefit. The fifth type of benefit is a death benefit, with a maximum of $320,000 and a burial benefit of $10,000. This is a possible benefit even if only 1% of the cause of death is related to employment. So cancer cases or heart attack cases or aggravation of diabetes cases, these could all be covered under the California Work Comp Death Benefit for injured workers' families, even if, again, only 1% of the cause of death is related to employment. Of course, unfortunately, there are also death cases due to accidents that happen directly on the job, which may also be successful cases. Eventually, work comp cases resolve by one of two types of settlements if the case does not go to trial. The first is a stipulation with request for award. That is where both parties agree to resolve the level of permanent disability, which is paid out over time, and whether you will receive future medical care. Again, the future medical care is not like regular health insurance. The injured worker, even with the award, still has to show throughout their lifetime that the need for treatment is related to the injury and subject to, at least for now, the law that requires utilization review and independent medical review. The second type of settlement is a compromise and release. This is where the injured worker or their family on a death case receives one lump sum and the insurance company or self-insured employer shreds their file. Their file is closed except for maybe the vocational retraining. That lump sum is not taxable, but if you're on Medicare, there are a lot of rules about how you can use your lump sum. Having an attorney at that point is very important in order to assess whether the offer by the defendant is reasonable. If the parties cannot reach a settlement, then the judge makes a determination as to the level of disability and what parts of body should be covered under future medical care, or whether someone's death is related to their employment and the case should be accepted. The judge cannot force the defendant to do a lump sum, and the judge cannot force the injured worker to take a lump sum. Therefore, if a judge makes an award, it's paid out like a stipulated award. The disability percentage of money is paid over time for some amount of time, and the possible future medical care is left open. Each case is different, and the date of injury has a significant impact on what benefits you may be due. As a disclaimer, of course, this information is intended for general purposes only and not specific legal advice. You should be aware that any person who makes any false statement for the purpose of obtaining or denying work comp benefits is guilty of a felony. We here at the Injury and Disability Law Center hope that this information will assist you in understanding the California work comp system and how an attorney may help you win your case. Our law firm is committed to helping injured workers and their families and is a member of the Work Comp section of the California State Bar and the California Applicants Attorneys Association.